Good afternoon and welcome to Thompson Coburn's Higher Education Litigation Roundtable. This is where we discuss all the important cases affecting higher education. And needless to say, there's obviously a lot going on. That said, we only have an hour today, so we will endeavor to discuss all the important cases to you and your institution. But if there are certain areas that we do not get to, or there are questions that we do not answer, please feel free to reach out to me or any of my co-presenters directly and ask us any questions you may have. My name is Trey Cleveland. I'm a co-chair of Thompson Coburn's Higher Education Practice Group. I focus on litigation, as do all my co-presenters, who are my colleagues here at Thompson Coburn. Today you'll hear from myself, and then Brant Hill, Anna Knaus, Evan Maltz, and Laurie Hargrove. And Thompson Coburn is a full-service law firm with over 400 attorneys in various legal markets in large metros across the country. Our higher education practice group focuses on representing institutions in all matters, whether it be regulatory, corporate compliance, mergers and acquisitions, change of controls, litigation, and government relations and lobbying work with all types of institutions across the country, whether it be nonprofit, for-profit, private, or public institutions. Now, every good college course has a syllabus, and our webinar is no different. After some initial housekeeping and introductions, you're going to hear the following topics today: the department's RIF, gainful employment and BDR litigation, grant termination, the False Claims Act, international student litigation, federal funding freeze, disparate impact executive order, DEI and the Dear Colleague letter, and the future of nationwide injunctions. As I stated, we only have an hour. We have a lot to cover, and we may not answer all of your questions. In addition to reaching out to panel members, many of you know that our practice group is now publishing a bi-weekly newsletter where we discuss all the cases affecting higher education. And so if you're not already receiving that newsletter, please let us know. Our latest iteration was published yesterday. And if you have cases that you would like for us to cover in the newsletter, we would be happy to do that. So we'd appreciate any feedback. Also, we hope many of you are going to attend the upcoming NACUA conference in Seattle this month. Thompson Coburn will be hosting an event on Monday, June 23rd at 12:30 p.m. right after the sessions end. It will be at the Thompson Hotel on a rooftop overlooking the water in Seattle with food and drinks. So how bad can it be? Free beer will be provided. I've got a little bit of housekeeping information that I need to provide, and I'll do that. At the bottom of your screen, there is a question and answer widget. If you want to ask a question, please use that. There is additionally, if you need help, there is a help widget at the bottom of your screen. Please use that. It should give you some basic technical advice. And there's also the resource widget. This webinar PowerPoint deck will be in our resource widget, and you can download that. We have a whole host of other information. Please use what you would like. And additionally, there is a post-webinar survey we would appreciate you completing. Also, there is CLE credit for Texas, California, Missouri, Illinois, and there will be questions throughout to receive credit for the CLE if you registered for that. A little bit of a cheat sheet here. Pay attention after slides number 35, 45, and 63. Look for some questions, answer those in multiple choice, and you'll receive your CLE credit. Additionally, this is not legal advice. We are lawyers, but today is for informational purposes only. If you need legal advice or you have a particular situation that you need to hire an attorney, please consult an attorney. Obviously, we would love to be your attorneys, but we would have to be retained to do that. So again, if you have any questions, please let us know. But with that, we'll get started with the webinar. And I'll start and I'll talk about the reduction in force and the executive order to dismantle the Department of Education. It was no secret that on the campaign trail, former President Trump, seeking re-election in 2024, centered a large portion of his education policy on ending the Department of Education and certainly reducing its size dramatically. It was no surprise that on March 11th, the department initiated a RIF where many media outlets reported that the reduction in size went from some 4,100 employees to approximately 2,100 employees. There had been a lot of sort of false starts regarding the reduction in size of the department and a potential executive order to end the Department of Education. So again, when this happened in May, no one was surprised. I think the administration's opponents were ready to file litigation at a moment's notice. And 2 days after the RIF, 19 states and the District of Columbia filed suit in Massachusetts seeking to enjoin the RIF. The next day, there was a similar suit filed in D.C., also seeking a preliminary injunction. And then a few days after that, a much anticipated executive order. I'm sure many of you followed it in the media. It was previewed several times prior to March, but it finally came on March 20th, and this was the Dismantle the Department of Education executive order, where President Trump instructed the secretary to take all maximum steps possible to close the Department of Education. Very quickly after this executive order, there were two lawsuits filed, one in Maryland and one in Massachusetts, and they both sought preliminary injunctions to prevent the implementation of this executive order. Well, given that there were two cases, one covering the RIF and one covering the executive order in Massachusetts, the administration asked those courts, those cases, to file one consolidated brief in the two cases. The department was allowed to do that. And on May 22nd, 2025, the Massachusetts court, it ruled in favor of the petitioners, and it issued a preliminary injunction doing a few things. One, it required the department to reinstate more than the 2,000 employees it had dismissed under the RIF, and it further enjoined the department from carrying out the dismantle of the Department of Education executive order. Very quickly, the Trump administration asked the district court to stay the preliminary injunction, at least while the litigation progressed to the First Circuit Court of Appeals. The district court declined to do that. The First Circuit very quickly declined to grant an administrative stay on May 27th, but indicated it would be quickly ruling on the substantive stay request from the department. And on June 4th, the First Circuit denied the Trump administration's request for a stay and reiterated that the dismantle of the department executive order is enjoined and that the department must immediately reinstate terminated employees. And then just last week, 2 days after that, on June the 6th, the department filed an application to stay the injunction with the U.S. Supreme Court. And Justice Jackson with the court has required that the parties need to provide briefing by this Friday, June the 13th. So we shall see. Hopefully by our next iteration of our bi-weekly newsletter, we'll have an answer to this. But we shall see, I think, fairly quickly what the Supreme Court says about both the RIF and the Department of Education dismantle executive order. But as it currently sits, the RIF is technically supposed to be undone. I think they will find it very hard to rehire 2,000 people. I think many of the former staff of the department have moved on to other things in life. But certainly the dismantle of the Department of Education executive order is currently on ice. Moving on to gainful employment and financial value transparency. Obviously, this rule goes back to its final publication in October of 2023. And under the rule, the department will calculate and disclose debt to income ratios and provide a new earnings premium. And this earnings premium will be for every Title IV program, meaning both GE and non-GE programs. And prior to the rule's implementation in October 1st of 2024, which the rule did take effect then, there were two lawsuits filed in the Northern District of Texas What is interesting, and I'm sure many of you followed these, was that the decision made in the summer of 2024, last summer, regarding the GE preliminary injunction, that was made just days before the U.S. Supreme Court's Loper-Bright decision, which was all the rave last year. And the Loper-Bright decision undid Chevron deference. And maybe the district court would have come to a different conclusion had it ruled after the Loper-Bright decision. We don't know that. But certainly the district court did decline to grant a preliminary injunction. After President Trump was inaugurated, the department asked the court in Texas to provide a 90-day briefing stay so that the department could become more familiar and reevaluate their position as it relates to gainful employment. And then what was considered just a complete shocker, on May 16th, the Trump administration, in briefing in the district court in Texas, revealed that it would sort of full throat defend the Biden-era gainful employment rule. Again, this was a complete 180 from what most people assumed the DOJ and the Department of Education would do in that litigation. And it was so shocking, if you think about going back to 2019, when Trump all but rescinded the previous Obama gainful employment rule, which is very similar to the Biden rule. Back then, the Trump administration said that the GE rule is fundamentally flawed and inconsistent. It failed to properly account for factors. It failed to provide transparency. It wrongfully targeted some academic programs, and that it may result in lesser outcomes and higher student debt. So the fact that the Trump administration has apparently done a 180 and is now going to defend this type of rule really is shocking. That said, trying to read the tea leaves, if you will, a bit about where this litigation will go. Obviously, there's two different components to the rule: the gainful employment rule with the penalties and enforcement, and the financial value transparency rule with the data collection. Many think that the department is signaling that it wants to continue the FVT framework so that it can continue to gather information. Obviously, there are certain universities that have at least caught the ire of the Trump administration to date. And it is possible that maybe the administration would like to get as much information as it can regarding certain universities and use that in down the line. Again, to be seen. Also, I'm sure many of you are following this, under the current House version of the reconciliation package, the one big beautiful bill, gainful employment, the legal basis under the Higher Education Act is being stripped out of law. But yesterday, the Senate Help Committee, or it may have even been early this morning, sent out its draft budget reconciliation, and it does not eliminate the gainful employment language. So again, we've got some reconciliation to do, if you will, between the House and the Senate to see where this ends up. But keep in mind that even if the gainful employment language is stripped in the one big beautiful bill, it will not prevent the FTV framework, and that still may stand. What I would say, and what I think our team's impression is here is, while it is shocking in a 180 decision by the Trump administration to defend the gainful employment rule, I think our impression is that we suspect that the DOJ probably pressured Ed a bit to preserve the Secretary's authority to the maximum extent possible. And so we've got a ways to go, both in Congress and in this litigation. But as it stands now, the gainful employment is fully implemented. Obviously, the reporting requirements have now been stayed until September from the department, but we shall see where this ends up. I will say, I personally find it very interesting that this will probably be, because the preliminary injunction was decided prior to the Loper-Bright decision, this may well be the first major decision we get under the Loper-Bright framework to see what type of authority the administrative agency has as it relates to the Department of Education. So again, I think this litigation is fascinating, but it's got a ways to go before we get a determination. Moving on quickly to BDR, and then I also have a little bit of extra credit that wasn't on the syllabus about the bare minimum rule of Title IX, but I will cover these quickly as I know we have limited time. The BDR rule, the 2022 Biden rule, was set to take effect on July 1st, 2023. There career colleges and schools of Texas filed litigation in the Western District of Texas seeking to enjoin that rule. However, the district court, I think it surprised a lot of people, declined to grant the preliminary injunction. But in April 2024, the Fifth Circuit Court of Appeals on appeal directed the district court to enter a nationwide injunction. So as we stand today, the borrower defense rule is enjoined, but there is some interesting information. Obviously, during the Biden administration, prior to the election in 2024, the administration sought the Supreme Court to intervene and overturn the Fifth Circuit's injunction. But 4 days after President Trump's inauguration, his administration filed a motion with the Supreme Court to delay that briefing schedule so it could reassess the soundness of the borrower defense litigation. But again, and similar to GE, on May 29th, the department filed a Supreme Court a motion to resume the merits briefing, and it's stating that it was adhering to the position that the Higher Education Act allows for the borrower defense rules, but that it intended to replace the 2022 rule with its own rule, which I assume may look like the previous borrower defense rule, which is now what's being implemented since the Biden rule has been enjoined, but we shall see. And again, I will state that the Health Committee from the Senate, their budget package, at least as it stands, would eliminate borrower defense as a possibility under the law. So again, we've got a ways to go in this litigation. It is fascinating. It affects a lot of institutions. And with that, I'm going to give just a little bit of a bare update, if you will, on the bare minimum rule. The bare minimum rule is still enjoined. There's a national injunction from the Northern District of Texas. In Title IX, that rule was completely vacated by the Eastern District of Kentucky, and there was a Dear Colleague letter issued by the department stating that it will be enforcing the 2020 Title IX regulation. So I'm sure all institutions have dusted off its prior rule from the Trump administration and is now implementing that rule. And with that, I'm going to turn over to my good friend and colleague, Grant Hill, to talk about the grant termination litigation. Grant?
Thank you, Trey, and good afternoon, folks. My name is Brant Hill, and I'm going to be talking about the recent litigation over the termination of education grants. And there has been a lot of it lately. Since the new administration took over in January, the Department of Education, the National Institutes of Health, and many other agencies have terminated thousands of education-related grants, by and large because of the new administration's anti-DEI policies. Lots of lawsuits have been filed challenging these terminations and seeking preliminary injunctions to have the grants reinstated. And there are new court decisions coming out, what it seems like, on a daily basis, most of them in favor of the plaintiffs in reinstating those grants, but not all of them. There have been some cases that have been in favor of the government for procedural reasons. And so for the next 10, 12 minutes or so, I'm going to cover how and why these grants are being terminated and where all this litigation stands. So jumping right into it, all the grants that I'm talking about today have been authorized by federal law, and they are required to be awarded by the agency. There are a lot of different types of grants that are being terminated these days. Some go to institutions, some to states to fund academic programs that benefit students. Some are awarded to individual researchers, and there are many others, and I've listed a few examples here on this slide. But the important point for today's purposes is that the grants being terminated are all considered discretionary grants. But the term discretionary is really a little bit misleading. These grants are considered discretionary in the sense that agencies can choose who to award the grant to in the first place, but not in the sense that they can terminate these grants whenever they want. And just at a 50,000-foot level, how this award process works is that an agency will invite applications for the grant. And the agencies will tell potential applicants, hey, we're going to award these grants to those applicants that best meet certain priorities that we have adopted. But this is important. These priorities can't just be made up by the agencies on the fly. They have to be established by the agency by going through a public notice and comment rulemaking process. And only after that process is over and after the agency invites the applications and reviews them, then the agencies select which applicants best meet its priorities and awards them the grants. These grants are typically for somewhere between 1 and 7 years, depending on the specific grant at issue. So the agencies do have discretion on who to award the grant to, but once it awards it, its discretion to terminate the grant is really pretty limited. A grant recipient has to be violating the terms of the grant award, which are the federal laws and regulations that apply to the specific program, or the grant recipient has to not meet various reporting obligations that it has to satisfy under the grant. But outside of that, really the only time that an agency has authority to terminate a grant is if the grant program no longer effectuates the agency's goals or priorities. But again, those priorities get established through the notice and comment rulemaking process. They can't be created on a whim by an agency just because an agency doesn't like the priorities previously established, perhaps under a prior administration, when that grant was first awarded. So if an agency wants to rely on this authority to terminate a grant, it's got to go through the notice and comment rulemaking process first. So that is how the process has worked historically, but of course things change a little bit. In January, when President Trump issued the 2 DEI executive orders that told federal agencies to terminate illegal DEI or equity-related federal grants. And not long after those executive orders were issued, the Department of Education, NIH, and other agencies began canceling all kinds of education-related grants right in the middle of the grant life cycle. And they have done that by sending pretty much boilerplate letters to grant recipients saying their grants were being terminated for various reasons, such as the grants promoted illegal DEI practices or the grants conflicted with and no longer effectuated the agency's priorities. So these grants are being terminated for what are clearly policy reasons, mainly anti-DEI related reasons. And so, naturally in response, the recipients of these grants are bringing litigation. And in all these cases, the plaintiffs are suing under the Administrative Procedure Act, or the APA. And the APA is a federal law that governs the review by courts of federal agency decisions, like a decision to terminate a grant. And just in a nutshell, what the APA says is that an agency decision is unlawful if it's arbitrary and capricious, meaning the decision is not backed up by any kind of facts or evidence or any reasonable explanation. And so in nearly all these cases, the plaintiffs, the grant recipients, are seeking a preliminary injunction to get their grants reinstated on a temporary basis while the merits of the lawsuit plays out and the court makes a final ruling. So just to be clear, a preliminary injunction, it's not a final ruling by the court. It just gives interim relief to a party while the court has more time to consider the merits of the case and make a final ruling. And for most grant recipients, getting that preliminary injunction and getting the grant reinstated is critical because it usually takes several months, if not years, for the court to make a final ruling in a case. And so that's why you're seeing so many lawsuits these days that ask for this immediate injunctive relief. Now, the preliminary injunction analysis looks at a few factors, but the two main ones are, is the plaintiff likely to win on the merits of their claims at the end of the case when it's all said and done? And then second, courts ask, is the harm to the plaintiff if an injunction is not entered greater than the harm to the government if an injunction is entered? Now, there have been dozens of cases in the last several months addressing this exact issue, some involving terminated education grants, some involving non-education grants. But by and large, the large majority of these cases have resulted in a preliminary injunction being entered that requires the agency to reinstate the terminated grants. And the courts are finding that these terminations were likely arbitrary and capricious. Why? Well, they're sending boilerplate letters to recipients. There's no individualized analysis of the recipient's program, and there's no analysis of the facts and circumstances that led the agency to terminate a particular recipient's grant. And second, the agencies, including the Department of Education, hasn't gone through the notice and comment rulemaking process such that it can't terminate a grant based on its anti-DEI priorities. And in most cases, the courts are also finding that the harm to the plaintiffs, these grant recipients, if they don't get their grants reinstated immediately, outweighs the harm to the agency. And in many cases, that's pretty much self-evident. If you are a school and your grant program relies solely on grant funding, federal funding, and you don't get that funding back immediately, it might not ultimately matter if you win the case down the road in a year or two, because you won't have the financial resources to keep your program running in the meantime. You'll have to shut down your program, lay off employees, stop critical research, and so forth. And on the other hand, the government, the harm to the government is pretty minimal, because if the government wins the case down the road, it can always seek to recoup those funds from the grant recipient. So the government's harm is really purely financial. Now, there have been some cases, however, going the other way. And the most notable one is the litigation involving the Department of Education's termination of over 100 teacher-related grants back in February. These are grants that were awarded to institutions to recruit and train minority students who will ultimately work as elementary school teachers in underserved communities. And the department, again, terminated these grants because they promoted legal DEI and their grants were inconsistent with the department's due priorities. In other words, the department canceled these grants because their programs did exactly what Congress had authorized them to do. And so a couple lawsuits were filed against the department. In both these cases, the district courts issued preliminary injunctions, reinstated the grants, but then the department asked the Supreme Court in one of the cases to stay the injunction, put the injunction on ice, and effectively re-terminate the grants while the case proceeded to a final ruling on the merits. And by a 5-4 majority, the Supreme Court in April ruled for the department. And what the Supreme Court said, or what the majority said, really has nothing to do with the merits of the case at all, meaning nothing to do with whether the agency unlawfully terminated the grant. Instead, what it said was the federal district court, where the plaintiffs sued the department, likely lacked jurisdiction to hear the plaintiffs' APA claims in the first place. What does that mean? Well, this is pretty technical, but basically it means that the Supreme Court didn't think their plaintiffs filed their lawsuit in the right court. There is a federal law called the Tucker Act. And what it says is that if you are a plaintiff and you bring your claim against the government seeking the payment of money owed under a contract with the government, then your claim must be brought in the Court of Federal Claims. And the Court of Federal Claims is a completely different type of federal court, unlike federal district courts. And the Court of Federal Claims only hears certain types of claims, specifically claims for money involving contract disputes with the government. And so the Supreme Court here said to the plaintiffs, you can't bring your APA claim in federal district court because your claim is seeking money owed under a grant with the government, and a grant is like a contract. Well, the plaintiffs had argued, well, we're not actually seeking the payment of any specific amount of money owed to us under this grant. We're just seeking the reinstatement of our grants moving forward. Well, of course, these grant recipients, they do receive money from the government under their grants. And there's a pretty blurry distinction between claims that directly seek money from the government in claims that don't directly seek money, but that seek an injunction that incidentally impacts the disbursement of money. And if that sounds confusing, it's because it is. But until this Supreme Court ruling, the case law really supported the plaintiff's position, and that is what the dissent pointed out. Nevertheless, the majority disagreed and said plaintiffs probably should have brought their suit in the Court of Federal Claims. So what is the impact of this ruling? Well, again, the merits haven't been decided at all. The Supreme Court just said that the case probably belongs in the Court of Federal Claims, but it's not even there yet. The case has actually been sent back down to the lower courts, and there the department has formally asked the lower court to send the case to the Court of Federal Claims. No ruling on that issue, so we'll have to see what happens there. But beyond this teacher grant litigation, unsurprisingly, the government has been waving around this Supreme Court ruling in every other grant termination lawsuit and saying, hey, look at what the Supreme Court said. This case belongs in the Court of Federal Claims too. After all, Supreme Court is the final decision maker when it comes to what the law means, right? Well, surprisingly, since that Supreme Court ruling, several courts have actually not followed the California decision. And what we're seeing is that those lower courts that are inclined to rule favorably for the plaintiffs on the merits in these cases are going to great lengths to try and distinguish the facts of their case from the facts in the California case. And in fact, there's been over a dozen opinions since April that have said California, the ruling in California is not binding on that. And there are really two critical things that distinguish these cases from the California case. And the first is that the plaintiffs in California did not bring a claim against the government under the Constitution. They only brought APA claims. And the case law says that if a plaintiff alleges a violation of the Constitution, then the claim is not in the jurisdiction of the Court of Federal Claims. It can be brought in federal district court. And the second distinguishing factor is that in California, the plaintiffs had asked for an injunction not only to have their grants reinstated, but they also asked for backwards looking relief in the form of reimbursement for past due payment obligations. And in all these other cases, at least these 12 other cases since California, the plaintiffs have only been seeking relief on a forward-looking basis. And so just as a matter of practical advice, if your school has a grant and that grant is terminated, before you sue, you want to make sure that you understand the consequences of what claims you are bringing, meaning APA claims and or constitutional claims, as well as what type of relief you're seeking, forward-looking relief or backward-looking relief or both, because that can very well decide where your claims ultimately get heard. Generally, the reason that most plaintiffs, most grant recipients don't want to be in the Court of Federal Claims is that the judges on that court historically have been favorable to the government. So one last thing, I just want to very briefly cover the NIH grant termination litigation. There have been several lawsuits that have been filed. Plaintiffs in these cases, including researchers at Columbia and Harvard, are the plaintiffs. And as of today, no preliminary injunction has been entered. So the NIH grants remain terminated as of now, but no court has declined to issue a preliminary injunction. It just hasn't ruled on them yet. We need to get moving to the next presenter. That's Anna Canal. So I'm just going to quickly move on and pass it to her. But before that, we have today's first secret word that you will need to enter on your screen. And that secret word is blue. So we'll give you about 15, 20 seconds to do that. and then I will hand it over to Anna to present next. Thank you.
Just give it about 15 more seconds before I change the slide. Okay, I'm gonna change it off of the secret word blue for any last few. Hi everyone, my name is Anna Knaus, and I'm gonna quickly address the False Claims Act and international student litigation. So starting with the False Claims Act, as many of you know, the False Claims Act applies to any entity or individual that accepts federal funds and makes a knowingly false statement to the government in receipt of those funds. So what the False Claims Act does is it allows the government to recoup funds that are allegedly fraudulently obtained. And specifically, it allows for qui tam suits, and qui tam suit is a whistleblower suit where a private individual brings the action on behalf of the government, and then as a reward for bringing that action, they get recovery of some of the funds. So the False Claims Act is very long-standing. It's been in place since 1863, but in September of 2024, a district court in Florida issued a decision declaring the qui tam provision unconstitutional, which is the first ruling of its kind. And that ruling is currently pending appeal in the 11th Circuit. However, if it is upheld, it will raise some questions about the future of whistleblower litigation. Specifically, that case, they said that the government, because the government didn't intervene, that it was an unconstitutional exercise of authority by an individual. So there would be a question, if it is upheld, of whether or not whistleblower actions could be limited to only cases where the government intervenes, or they could possibly be eliminated altogether. However, the Department of Justice recently let us know where they stand on the False Claims Act. And on May 19th, they announced that they're establishing a civil rights fraud initiative. This civil rights fraud initiative designates a DOJ attorney in each field office to serve as an investigator. And they are encouraged to work with the Civil Fraud Division, the Civil Rights Division, and the Criminal Division. So the implication of that is that violations of the False Claims Act could result in both criminal and civil penalties. Specifically, the initiative encourages the reporting and filing of suits by whistleblowers, and specifically mentions entities that have programs that engage in, quote, DEI and racial preferences. And it specifically mentions the Students for Fair Housing and Harvard decision. So they've let us know loud and clear that they're going to continue to pursue False Claims Act cases in the meantime. And then next, I am going to touch on the international student litigation. I'm going to start with the lawsuits filed by Harvard because they are illustrative of the two kinds of barriers facing international students right now. The first issue is the revocation of visas for existing students, and the second issue is barriers to entry to the country and also barriers to obtaining a visa for prospective students. So on May 22nd, the Department of Homeland Security announced that it was going to revoke Harvard's ability to participate in the Student and Exchange Visitor Program, which is the program that allows institutions to be able to sponsor visas for international students. The next day, Harvard filed a lawsuit and moved for a temporary restraining order with regard to the revocation of their ability to participate in the SEVP. A judge in Massachusetts immediately granted the temporary restraining order. and set a hearing for May 29th. At that hearing, the judge told the litigants that she was planning on entering a preliminary injunction. So right now it was just a temporary restraining order, but she indicated a further preliminary injunction would be entered. However, after that hearing on June 4th, President Trump issued a proclamation immediately suspending entry of international students who attempted to enter the country to attend Harvard, and then also directed the Secretary of State to revoke the visas of international students currently attending Harvard. So the next day, June 5th, Harvard amended their complaint and moved for a temporary restraining order as to that proclamation. On June 5th, the court granted the motion for the temporary restraining order and specifically mentioned the first temporary restraining order and indicated that both temporary restraining orders are in effect. The government is enjoined from revoking their ability to participate in the student exchange visa, the SEVP, and the SEVIS, the one that issues the visas, and enjoined the government from preventing entry of the students. So currently both are enjoined. On the other side of the country, individual students from other institutions are also challenging the revocation of their individual F1 visas. So in April, certain students realized by looking at the student and exchange visitor information system that they had active visas that had been changed to terminated, and they filed suit. On May 22nd, a judge in a California district court granted the motion for the preliminary injunction and issued a nationwide injunction for similarly situated students. So right now, there is a nationwide injunction on the government and the Department of Homeland Security, enjoining them from terminating visas as to current students. As to Harvard, they are enjoined from preventing entry. So also on June 4th, President Trump issued an additional proclamation that was untethered to a specific university or institution, but just a blanket travel ban prohibiting entry from nationals of 12 countries into the United States, and then partial restrictions on an additional 7 countries. So as of right now, that travel ban has not been challenged. However, it is probably going to face challenges soon, just like the first travel ban that President Trump issued during his first term. However, that previous ban was ultimately upheld by the Supreme Court in 2018. And so if there are challenges, they will probably have to be on different grounds because there is precedent allowing the first travel ban. And that was a lot of information, but with that, I'm going to turn it over to Evan to talk about federal funding freezes.
Thanks, Anna. I'm Evan Moltz, and I'm going to touch briefly to start with on the federal funding freeze. And this is the litigation that involves the executive order and Office of Management and Budget's memorandum that temporarily paused the disbursement of federal funds so that the government could assess whether the spending was in line with a handful of executive orders that the president issued in his first week in office. 2 courts have entered preliminary injunctions enjoining the government from effectuating both the executive order and the OMB memo and essentially the federal freeze. So the government has appealed both of those injunctions, but for the time being, the injunctions are still in force, and they will go through the appellate process, which should take some time. So there's not a whole lot going on in this case right now, or these cases. It's unlikely that these cases will have much activity for the next several months. Before I get into the next topic, we're going to have our second secret word, which is sky. So go ahead and enter that on your screen now, and we'll give you about 30 seconds or so to complete that questionnaire. right, we're going to go ahead and move on now to talk about disparate impact liability. And there's been a couple significant developments in this area of the law that I think has some importance to the higher education world. Disparate impact liability is a legal concept that where essentially permits a facially neutral or non-discriminatory policy or practice to be challenged if there's proof that it has a disproportionate or negative effect on certain protected classes, regardless of whether there was a discriminatory intent when to enact or implement the policy or practice. We see this in various areas of the law, but two that I think are particularly relevant right now are Title VI and Title VII. Title VI prohibits discrimination by recipients of federal financial aid, and Title VII prohibits discrimination in the employment context. Both Title VI and Title VII contemplate imposing disparate impact liability. Title VI does so in the statute. It does not do so in the statute itself. It does so in the regulations. Title VII, the prohibition is in the statute itself, which could be important going down the road here. But in these two areas in particular, there's been these two significant developments, one being a Supreme Court decision on Title VII, and one is an executive order that affects disparate impact liability more broadly and has a specific reference to Title VI. So with Title VII, the Supreme Court case that just came out last week clarified the standard on disparate impact liability that involves claims brought by someone who is a member of the majority group. Up until the Supreme Court ruled, there was a split among courts on whether members of the majority group had to prove some heightened evidentiary burden than members of a minority group. In those places where there was a split and the heightened standard was applied to members of the majority group, they also had to prove what were background circumstances suggesting that the defendant was an unusual employer who discriminates against the majority. The Supreme Court unanimously rejected that standard. And the result is essentially that members of the majority and members of the minority have the same burden of proof when it comes to a Title VII employment discrimination claim that is based on a disparate impact theory of liability. Depending on how you view that, whether it is, in line with what the president is doing or not, it is interesting because the White House issued an executive order in April that sought to eliminate the use of disparate impact liability in all contexts. But in doing so, the president specifically called out Title VI and directed the Department of Justice and certain other agencies to take specific actions related to the regulations that implement and enforce the Title VI statute as they relate to disparate impact liability. And one of those actions was to either amend or repeal the disparate impact regulations in their entirety. So there hasn't been any challenges yet to this executive order. It's likely that it will be challenged at some point, just like most other executive orders that have come out so far. One area where you could see some type of legal challenges if there was a flaw or defect in the process to amend or repeal the regulations. But for now, the executive order is in force, so it's likely that you will see some lessened enforcement on disparate impact theories of liability in Title VI and Title VII. But it's important to remember that Title VII still has a viable cause of action or provides a viable cause of action for employees on a disparate impact theory, unless and until Congress amends the statute. So I know we moved through fast. We're kind of getting towards the end of time, and I want to make sure that we have time for Lori to talk to you now about DEI and the nationwide injunction. So I'm going to turn it over to her.
Thank you, Evan. We're going to start briefly with the DEI world, which was so busy there for a while, so much happening. We're only going to cover it briefly because right now there's sort of a stationary point in it. I know that a lot has been happening with grants that Brant already covered. The 2 DEI executive orders that Brant mentioned earlier that were put in place right after President Trump took office, those have been challenged in litigation. And the important thing to know right now is that they are both essentially in force. There was a nationwide injunction that was entered against them, but the Fourth Circuit entered a stay of that injunction, and so now they are back in force. Moving on to the next one, the Education Department's Dear Colleague letter, the February 14th letter, the FAQ that followed that, and the DEI portal that was put into place, as well as the April 3rd certification requirement. Those have all as well been challenged. And as of now, they have all been stayed, which means they are not in force as of right now. Let's move on to the next topic. We're going to talk about nationwide injunctions. This has been an incredibly powerful tool in the federal judiciary's arsenal as a check and balance on the kind of executive power that we've seen taking place, not only with this administration, but it was also used a lot with the Obama administration and the Biden administration. And all of these presidents have complained about it. And over time, there has been more and more criticism growing about the idea of one federal district court judge being able to enjoin the executive order of the President of the United States. And the types of criticisms that have been in place are just that, one, it encourages forum shopping. You know, when Biden and Obama were in office, we were seeing a lot of nationwide injunctions coming out of Texas. And now that it's Trump's executive orders that are being challenged, we're seeing a lot of nationwide injunctions coming out of, most recently, the District of Massachusetts. But for now, right now, a nationwide or universal injunction issued by a single federal district court enjoining the executive order of the president is allowed. The Supreme Court has accepted this issue for review in the Trump versus Casa case. It heard oral argument on May 15th. Frequently, oral argument will give you sort of a crystal ball where you think the court is going. This oral argument really did not, but the mere fact that they've accepted the issue tells us that they're probably going to do something with it. And, you know, there's a couple different ways that they could rule. They could completely eliminate the nationwide injunction, or they could just issue some new parameters that potentially would make them more difficult to get. You know, for those institutions that are relying right now on nationwide injunctions, you need to think about what actions you might take if, in fact, the court rules either way, in a way where it gets rid of the nationwide injunctions. You may want to take a look at the existing litigation, the injunctions that are in place right now, and decide whether or not you're covered by them, even if there isn't a nationwide injunction. So, for example, last week I got this question at a presentation that I was doing, and it was from an institution that's located in a politically red state. And the gentleman was asking me, what can we do if the Supreme Court gets rid of these nationwide injunctions, the ones that we are relying on? What can we do? Because so many of these cases have been brought by either the blue states or the blue state AGs. So one thing to think about that institutions can think about is that some of these cases have been brought by associations that are representing many, many institutions, and you may be included as one of those. And so you may actually get the benefit of those injunctions, even if it's not a nationwide injunction. So you want to look at the existing litigation that's out there and determine whether or not your interests are already being included effectively as a party in the case if you're being represented by an association in the case. If you're not, if you look at the existing litigation, you have a nationwide injunction that right now you're really benefiting from, and you don't want to lose it. If you do lose it because the Supreme Court gets rid of the nationwide injunction, then you may want to consider any number of alternatives. You may want to file your own suit. However, there's power in numbers, and so because so many of these associations have gotten very involved in litigation, you may want to consider whether one of these associations would represent and file on behalf of its institutions the way it has in some of this other litigation. And another option is to seek to intervene in one of the cases where an injunction has already been entered. So, all right. Turn it back to you.
Yeah. Thank you, Lori. So we've got our final secret word, and please answer. Now I think we'll move on to questions. We've got a few minutes remaining. I'll give everyone a few more minutes on the final secret word.
I should add, Trey, that obviously the Supreme Court decision, the ruling is imminent. We are anxiously awaiting that every day, and there's no doubt our firm will do a blog post once it comes down, analyzing it to help everyone figure out what it means.
Right. I mean, I think there's a litany of different outcomes. I think everyone anticipates the rule is going to be different in some way, whether it's materially different and all the nationwide injunctions are grandfathered in and continue, or if they, immediately lose their effect across multiple jurisdictions, and that's to be determined. But yeah, and to your point, I would think if an institution is being covered by a national injunction and it loses that, quickly filing to intervene in the district court that issued, or the circuit court that issued the injunction, would be smart, because you already have a favorable judge who intended for their injunction to apply across the country. And I would imagine it would be almost a layup to, can't guarantee anything, but that the judge would allow intervention and then extend the injunction as broad as possible. So with that, we're going to move on to questions. Anyone have any questions? We have about 1 minute left. I don't see any in the queue. And I am seeing a comment that there was some confusion on what to answer the secret word, but any questions of that, you can certainly use the help widget if needed. Okay, so we've got a question, and this looks like a grant question. So Brant, I don't know if you can see it, but it's a termination notice from NIH that was sent by email, not a letterhead, and not signed. Folks, I think the question
I do see that question.
Go ahead.
Thanks, Trey. Yeah, I see that question. The question is that a recipient received a termination notice from NIH, and the termination notice was sent by email, not on letterhead, and it wasn't signed, and whether that is standard practice and whether to assume that it's real. That's a great question. All I can say is that a lot of grants have been terminated in recent months via email notices. Some have been via letter. I don't think that there is a legal distinction between a email termination notice and a letter termination notice. The important thing, though, is that the termination notice must come from it's the program official, the grant program official, who is a designated individual. It can't just be anyone at the agency. So that would be what I would look for as opposed to, placing importance on whether it's sent via email or via letter. Look for who the program official is. That name should be in the grant award notification that you receive, and make sure that your termination notice came from that person.
Right. Thank you, Brandon. And obviously following up and asking questions is always appropriate, and I would encourage the institution to do that. We are officially out of time. If others have any questions, all the panel members are more than happy to stick around and answer those. If you have questions you would rather email us directly or ask more privately, we'd be happy to answer those questions. We always appreciate the time. We would certainly appreciate any feedback for the post-webinar survey. Like I said, if there's any topics we are not covering in our bi-weekly newsletter, we'd be happy to do that. And once again, please look for us at NACUA on June 23rd. And seeing no further questions, I think we're concluded until next quarter, when we will have our then 5th iteration of Litigation Roundtable. But thank you all for attending.